All right, we're now recording. I'd like to thank everyone for joining the Mid-Atlantic Women in Agriculture Wednesday webinars. We would like to thank our sponsors of the webinars, as well as the collaborators. Listed here is the upcoming ones. Today is how to avoid the probate process. All webinars are recorded, and the past and future details on the webinars are located at the blue link here, extension.umd.edu/womeninag. So go to that page and you can see archived webinars that we have recorded, as well as upcoming ones throughout the rest of 2018. With that, I'm going to introduce Kelly Knuckles. She's with the University of Maryland Extension, and she's going to be our presenter today. Kelly?
Thank you, Shannon. So today I'm going to talk about avoiding the probate process as you begin to think about your farm transition plan, whether or not this is a primary goal for you and what you can do to avoid it if it is. First, I just want to say that some of this research and work has been supported by a grant funded by the United States Department of Agriculture, National Institute of Food and Agriculture, and the Northeast Extension Risk Management Education Center. I'm with the Ag Law Education Initiative, and on our website, which is posted right here, we have a number of legal resources available on estate planning specifically. So just other topics that you may be concerned about, I highly recommend checking out that website to learn more about estate planning topics. Just a general disclaimer, I am an attorney, but nothing that I say today should be construed as legal advice. State laws vary. Specifically, I reference Maryland and Delaware laws here, but if you live in another state, it may not apply. So just remember that it's always great to consult your attorney as you're thinking about how to formulate that estate plan. So today, first, I'm going to talk about what is probate, and then I'm going to talk about whether or not this is even a goal that you might be interested in. Do you even want to avoid probate or not? Does it matter when it comes to your farm transition? And then finally, I'm going to talk about how you can avoid the probate process. So first, what exactly is probate? Probate is when the court distributes your estate's property and pays all of your estate's debt. How does the court do this? Well, if you have a will, the court will distribute your property after all the debts are paid according to those instructions that are written into your will. If you do not have a will, state law will dictate exactly how your property will be distributed. So we'd always recommend, whether probate's a concern of yours or not, to at least have something in place, because if you don't have something like a will in place, state law will distribute your property and it may not go to exactly who you want it to go to. So what is in your estate? What exactly will have to go through this probate process if you have a will or if you don't have a will and you have no plan in place? First, it will be all of your real property. So that includes the land and anything attached to it, like your barns, your home, crops that are growing in the ground, and then all of your personal property. So that could be farm equipment, livestock, furniture in your home. But there are a few things that won't be included in the estate, and you won't have to worry about these things going through probate, and that is life insurance proceeds, pensions, stocks, or any benefit that's transferable on death to another person. With the probate process, there are several steps you will need to take and several documents you will need to have to probate that will. So first, you will file with the Register of Wills in the county where that person resided after that person's death. You'll probably need to take with you their death certificate, the latest dated will if they have one, a funeral contractor bill to help prove death, and then an approximate value of all of the assets in the estate. So This might take a while. You may need to even have an appraiser come out to estimate the value of certain assets, but make sure you bring that with you as well. And then any titles to like vehicles, farm equipment, anything that might have a title, make sure you bring that with you. In the state of Delaware, you have to probate an estate if it is worth more than $30,000 or if there is any of that real property involved, regardless of how much it costs. So again, any of the land or anything attached to it. Maryland's a little bit different. There is a quick and cheap probate process for estates that are under $30,000. So that's something to keep in mind. It may be quicker if your estate's worth a little less. If it's worth more, you may have to take more time and make sure you have everything in place to go through this probate process. Some things to consider when you're thinking about whether or not this is a priority for your farm transition plan are a few different things. First is the cost of probate. A lot of people don't want their property to go through probate because they think it's very expensive. For example, in Delaware, paperwork and just the original filing is between $60 and $500. And then there is a probate fee of 1.75% of the net worth of your estate, minus any of that real property. So real property won't be taken into consideration with that fee. So say, for example, you have money, equipment, and vehicles that are all worth $250,000, so $250,000. With that, the fee would be about $4,375. So that can be pretty costly for someone with an estate that's not that large. Then you need to think about the attorney's fees that will be added into that. So for example, the average right now, if you have to go through the probate process and it takes a long time, is anywhere from $10,000 to $15,000. So again, those fees and those attorney fees can add up pretty quickly. In Maryland, the fees are a little less, which is nice. If you maybe aren't as worried about probate, Maryland fees may not be a big concern to you. For example, in Maryland, it's just based on how much your estate's worth, and an estate worth $500,000 would only have to pay $750 as a fee, and then a estate worth $1 million would only have to pay $1,500 as a fee. So a little less in the state of Maryland compared to Delaware. Another big concern people have, and another reason why they want to avoid the probate process, is the time it takes to transfer that property through the court systems to the next generation. So I always tell people to think, what property in your farm operation will the next generation need to have immediate access to in order to continue on the farm business and to prevent any problems later on. When this property is tied up, you will not be an owner of it if you're an heir or the next generation that's inheriting that property. And this can be concerning if you really need to use that property as maybe collateral for an annual operating loan. Maybe you want to do certain things with it and you won't be able to if it has not completely gone through that probate process. So on average in both Maryland and Delaware, it takes about a year to get that property through the probate process. So that's something to think about. And then as well, wills can be easily contested, and that can make probate last even longer, about 1 to 5 years on average. So that's something to keep in mind too if you're worried about any potential family conflicts in the future, how long this could actually take, and will that next generation need access to that land or to that equipment right away? What will they be using as collateral for their loan? Do they already have property? Things to think about when you're considering whether or not probate is a great way to transfer certain pieces of farm property. Another reason people don't like probate is privacy concerns. So the probate process is public. These records will be filed in your county courthouse. but the likelihood of someone actually physically going to the courthouse and looking up your records might be pretty small. So again, if you are someone who wants to make sure for sure that is private, this is something that you should take into consideration. And then finally, just one other thing, if you own land in multiple states, you will have to probate that land in that state where the land is located. So some people who own property in multiple states don't like having to deal with probate for their land because they'll have to do it with 2 separate court systems and additional fees. So that's something to keep in mind as well when you're trying to decide whether or not to avoid the probate process. So things to think about: is this a priority for your farm transition plan, or is this not a priority for your farm transition plan? Are there some other goals that might be more important than avoiding probate? You need to sit down and talk with your family exactly where your priorities are. Will this even be a concern for the next generation or not? As I mentioned, they may already have land that they currently own or some sort of asset that they own that they can continue to use. They may not need to have immediate access to your farm assets to continue on with their farm business. So just kind of evaluate exactly what the next generation has and whether or not they'll be able to maybe wait a year or even more than a year to have complete control and access of that property. So there are several different tools if avoiding probate is a priority of your farm transition plan that you can use to avoid probate completely. So you can transfer your property without having to go through this process and avoid it completely. And I'm going to talk about each one of these in a little bit more detail here, but deeds, there are certain types of deeds and how you title your deeds that can help you avoid probate. Trusts are another popular tool. Business entities, you can gift or sell the property to the next generation before you pass away. There are different types of contracts that can help property avoid the probate process. And then, of course, as I mentioned, life insurance proceeds and retirement proceeds, retirement plan proceeds, these are not part of your estate, so they automatically avoid the probate process. So first, I'm going to talk about a life estate deed. And this is one tool that can help you avoid the probate process completely for any of your real property. So again, that's that land and anything attached to it. With this, you can name yourself or someone else if you want as a life tenant, but that life tenant will only have certain rights to the property during their lifetime. After that, the property will automatically go to someone called a remainderman upon the death of that life tenant. So, for example, you might designate yourself as a life tenant so you can continue to live on the property and use it and maybe even farm on it for the rest of your life. But then automatically on your death, whoever you've named as a remainderman, so maybe your children, automatically will receive that property, and the property will not go through the probate process. So if you do decide to maybe consider appointing yourself or someone else as a life tenant, you do need to consider exactly what rights they will have to transfer that property. There are 2 types of life estate deeds. One is a deed with rights and one is a deed without rights. So those rights that the life tenant has, they must be directly written into the deed. So for example, you would need to say that the life tenant still has the ability to sell or mortgage the property if they wish. But if you just write that in there, the right to sell and mortgage the property is not the right to gift the property on later on. So as a life tenant, you may change your mind, but you may not have control anymore, and you probably won't have control to give that property to someone else later on if you decide whoever you named as the remainderman should no longer receive the property. So just something to keep in mind if you're thinking about maybe doing a life estate deed, that you will probably lose some powers and some controls if you name yourself as the life tenant. You can also gift or sell any of your real property during your lifetime. You could just give it away completely to the next generation and make sure that the deed is retitled in their name before your death, or you could even sell it to the next generation and do a deed for sale. A few things to consider, especially if you're going to sell it, is income tax. If you're going to give it away, maybe triggering estate tax, although those limits are significantly higher now. And then just the fact that you will lose all control and considering whether or not you're ready to fully give up that property. There's also ways to title the deed to make sure that the property automatically transfers to a co-owner, specifically two types, joint tenancy and tenancy by the entirety. These are similar, except tenancy by the entirety is exclusively and only for married couples. With this, property will pass automatically to all living co-owners upon the death of one owner. So again, it will avoid the probate process completely. There are a few things that you will need to create a joint tenancy or tenancy by the entirety. Specifically, you must both or however many people are co-owners acquire the property at the exact same time. You must have the exact same title to the property. You must have equal shares, equal interest shares in the property, and then you must have the equal right to possess the entire property as a whole. So just some things to keep in mind, especially if maybe you don't want to have an equal ownership with whoever is your co-owner. This is a requirement of this type of titling on your deed. Specifically, if you're just looking at your deed, maybe later on and trying to determine whether you have a joint tenancy or not, joint tenancies do require really specific language in most cases and in most states. And usually it will say to Sue and Sarah as joint tenants with rights of survivorship and not as tenants in common. So it will say clearly with rights of survivorship, not tenants in common on that deed. And then you will know that you have a joint tenancy and it will automatically transfer to a co-owner upon your death. Now, this doesn't mean that you can't sell the property during your lifetime. If you decide you want to sell the property or even give it to another person during your lifetime, it will destroy that joint tenancy and it will no longer exist between you and that co-owner. But you will be able to make sure that upon your death it will automatically transfer if you do not do anything with it during your lifetime. So just some things to keep in mind when you're considering how to transfer that real property. Here's an example of joint tenancy. So a deed to farmland, which includes the barns and a home on it, lists a brother and sister as joint tenants. If the brother dies before the sister automatically receives full ownership of that real property, so the farmland, barns, and home. The brother's spouse that he has and any of his children will not have any rights to the property. Even if he, in his will, wrote in their names that they would inherit it, they will not inherit it. It automatically will go to the sister. So now the sister will be the sole owner, and we'll need to later on figure out how to transfer the farmland and barns and home to the next generation. So it's not something that will be foolproof to avoid probate for multiple generations, but for one generational transfer, it will be helpful. Of course, though, keep in mind the exception. If the brother has decided to sell or gift that property before his death, that would have destroyed the joint tenancy between the brother and the sister. Another tool that you can use to avoid the probate process is a trust. So I'm just going to go over some terminology for trusts. The grantor, trustor, or settler is the person who creates the trust, the person who places the property that they own into the trust. The trustee is the person that manages the property in the trust, and then the beneficiary is the person that will receive that property that's in the trust later on. A trust is a legal tool that holds the property that you placed into it and makes sure it's managed and is distributed based on your instructions. So with this, you as the trustee will place property into the trust, and then you will write specific instructions, probably with your attorney, on exactly who will receive that property and at what point they will receive that property. So there will be these instructions and guidelines on how to distribute the property. A person called, again, a trustee will make sure that that property is distributed based on your instructions. Any type of property can be put into a trust. You could put your land into it, cash, even your share of a business. And this will make sure that it will not go through the probate process. So anything placed in that trust will just automatically transfer ownership based on those instructions that you've written. There are a few different types of trusts. Testamentary trust is actually one that's created through a will. So again, that property won't avoid the probate process. So that's why it's crossed out on the slide. But anything in a living trust will avoid the probate process. So there are two different types of living trusts, a revocable living trust and an irrevocable trust. You may want to consider a revocable living trust if you're not sure you're ready to completely give up those assets. With a revocable living trust, you can go back later on and take your property back. If it's still in the trust, you can completely dissolve the trust, so you have a little more control over that property. With an irrevocable trust, you will not be able to get that property back. It will be permanently placed in that trust. So you really need to consider all different options that you have, and especially when you're writing your guidelines, all different things, including even potential deaths of future heirs, divorce, and other issues that may arise with your farm business. Just consider all the different scenarios, because especially if you have an irrevocable trust, you could have some issues later on with those instructions and being unable to change them. So just some things to consider if you want to avoid probate and you're thinking about using a living trust. Obviously, there are some positives, including avoiding probate. It also won't matter what state your property is in. So again, if you have land in multiple states, you won't have to go through the probate process in 2 states. You can just place that land into the trust. It also will help protect those assets from liabilities in the future, whether it's your liabilities or maybe some heirs that you are concerned about. Trusts are also a great source of income for minors in the future, especially since those instructions will be carefully followed to make sure that a minor still has a source of income if something were to happen to you. Trusts are also private. They're not open to the public, unlike probate. They're a lot harder to contest than wills, so the likelihood of things being tied up in court is significantly less. Some are flexible. Again, that revocable living trust is pretty flexible and easy to modify. And it could even assist with reducing the estate's worth for tax purposes. Some negative things that you might want to consider are the costly fees associated with trusts. They can be fairly expensive, even more expensive than a will, and maybe even going through the probate process, so that's something to consider. It could be difficult to manage the assets in the trust, especially if you have an irrevocable trust and those instructions don't quite fit the current situation. You may also not have everything in the trust that you own, so you may acquire new property later on and you've forgotten to place it into the trust. So that's something, it's very hard to remember to always be on top of keeping those assets in a trust. And then of course, with the irrevocable trust, it cannot be modified later on, especially if you change your mind and you want access to that property later on. Business entities are another way that you can help avoid the probate process for some of your property, but you do need to make sure that you have the right type of business entity in place to help transfer that property on to the next generation. So, for example, a sole proprietorship or partnership you probably don't want to use to transfer that property on, because it could dissolve upon the death of an owner or a co-owner. Instead, you might want to consider corporations or LLCs. With this, the business could take ownership control of those assets, so you don't need to worry about business decisions and using that property if a person's estate is being probated, because the land or whatever property you've given ownership to that business entity will be owned by that business entity, so it won't be owned by that person that has passed on. You also may be able to even get on top of a few issues. If someone owns shares in your business entity and those shares are maybe having to go through the probate process, you could consider a buy or sell out agreement in your operating agreement of your business entity, and this could just state upon the death of a co-owner, we have the right to buy out their shares for this amount. That way, a few shares, if you need certain voting rights, aren't tied up in the probate process later on. Contracts are also another way to help property avoid the probate process. The first one mentioned here is a contract for a deed. With this, it would put the current owner in the lender position. So if you're the current owner of the land, you could do a contract for deed with the next generation and then require them to make payments, ongoing payments for a certain amount of time to purchase that property from you. This contract will be upheld even after the original owner's death, and after that, their heirs will just receive those payments in the contract. Some great things about this is it could be a really great source of retirement income for the older generation, but you do need to consider, of course, any income tax consequences related to a contract for deed. There are also contracts for the transfer of ownership, and these basically just make sure the property is automatically transferred to a person upon the death of the original owner of that property. So again, helping to avoid that probate process. And with this, in Maryland and Delaware, you can do these contracts for the transfer of ownership for things like bank accounts, CDs, stocks, bonds, and even vehicles. So you can automatically transfer these things immediately upon death. And then finally, just a few other tools. Of course, you could gift or sell your property, any piece of property to the next generation before your death. As I mentioned, life insurance and retirement plan proceeds usually automatically go to a beneficiary on death. They don't go through that probate process because they're not considered part of your estate. And then there are a number of other investment opportunities out there, even some insurance options for long-term health care that can help make sure that there's a source of income that is not tied up in the probate process. And with that, I will go ahead and take some questions that I see are coming in. The first one is about how to, if you're interested in selling the land to a new and beginning farmer, but you don't have an heir in place, if there's any type of organization that can help make sure that that property is transferred to someone who is interested in purchasing it from you. And I will say that the USDA's Beginning Farmer and Rancher program does have some of those resources available. They also do a loan guarantee for up to 10 years, I believe. That can help make sure if that new and beginning farmer defaults on their loan to you, that they will make sure that payment's made. The USDA will guarantee that loan. The next question is about what the average cost of creating a trust is. And of course, this varies, but the national average is usually around $1,500 to $2,000 to create a trust. The next question is about if a trust, if you own land in multiple states, what state you might want to create a trust in, if it matters, and if it would be cheaper in one state versus the other. It really wouldn't matter what state you created that trust in. If you have an attorney in one state that you've been working with and you feel comfortable with and you trust to create your trust, I would recommend maybe asking them for a quote on how much it would cost. It never hurts to talk to multiple attorneys and see maybe who you feel the most comfortable with, and also exactly what their estimated pricing might be. The next question asks if you need to have other tools in place other than a will, or if a will be sufficient for your farm transition. I would say this really depends on your unique family situation, your farm's financial situation, what assets your farm even has. Every farm operation is different, so for some, a will may be sufficient. For others, you may need additional legal tools. That's why it's really important to go sit down and talk with an attorney or the attorney you've been working with for several years to make sure that whatever you have in place is going to help transition that property smoothly. And then the next question is about what is the most significant mistake families usually make when it comes to transitioning the farm on to the next generation. With that, I would say not exactly legally related, but it ties in is the fact that there are a lot of families that won't communicate and talk with each other about what the priorities are and what the goals are for their farm transition plan. And some will have it transition on without communicating at all to the next generation, and then it's a surprise upon the death of someone, and that can cause some family conflicts that result in this litigation that ties up your property for years. So communication and making sure you're discussing whatever is occurring with your farm transition is really important to help avoid some of those conflicts later on. Related to legal tools, I would say a common mistake is that people think that whatever the previous generation used or whatever their neighbor's using is what they need to use, and that may not necessarily be the case. As I mentioned, every farm operation is different, and every transition plan will probably be a little different. So you need to really sit down with your attorney and even an accountant and figure out what are the best tools you can use to transition the farm on. And that looks like that's all of the questions for today. So again, thank you for joining the webinar, and my email is down there as well as my telephone number if you have any questions in the future.
Great. Kelly, thanks so much.